Hello and welcome to LOLHSC Legal Studies HSC dot points tutorials, and the first part of the syllabus we're going to be going through is the crime. So we have the first area of the syllabus here, the nature of crime, just right in front of you on the screen, and we have to learn to the really important part are the learn tos. Is they're really what the questions are going to come from mainly. There are other areas which I'll go through in other videos. So we have, under the nature of crime, we have 5 questions, and really the first one, describing the nature of crime, has the most content. So there's 5 questions you have to ask yourself within this topic, within this little area of the crime syllabus, and that's: what is crime? How do we classify crime? What inherent tension is present? What are the elements of a crime? And are there any offences that don't require one of these elements? So straight away, what is crime? The Australian Legal Dictionary greatly defines this as: a crime can be defined as any conduct which violates the rights of the community at large, punishable by a recognised criminal sanction upon proof in a criminal proceeding initiated. That has some very important words in it, which you'll come to know as you go through legal studies more in your HSC year. Another part about crime which is slightly less important, however still important to note, that not acting is also a crime, and this is a perfect case study here, which is RV Thomas Sam / Manju Sam, in which they were charged with criminal negligence for refusing to allow the child to be treated with conventional medicine, and the child died. So as you can see there, that the crime was in actually not acting. So that was just kind of a side note. Move on to how do we classify crime. The main part, as you saw from the definition, is the rights of the society, and that's where public morality comes in. So really, the classification of crime can differ between societies due to this changing public morality, and the law that we have today is a reflection of this. This is really made evident when you compare two different centuries. We have 1735 and the Witchcraft Act, which shows a different society altogether, and the Crimes Amendment Computer Offences Act 2001, New South Wales, which relates to computer hacking. So you see the change in public morality as new technology has arisen and times have changed. So as you can see, that as witchcraft was a crime in 1735, computer hacking is a crime in 2001. A very important part, as this is addressed in other parts of the syllabus, is what inherent tension is present. Now what this tension is about is all about having a balance. Really, this tension comes from an attempt to balance the rights of the community and those individuals affected by crime, such as the victims, the family, and this really comes when you attempt to investigate, prosecute and punish criminal offences. Really the main thing there is that they have to balance it. They try to balance it, really. So that's kind of the aim, to have a balance of rights, so it's not too much in favour of the victims in achieving justice, but also the criminals, or kind of people charged or under investigation also have their rights too. Move on to another very important part, relating to what are the elements of a crime. Mens rea and actus reus. These are two very important words you have to learn. They're Latin terms. Mens rea means guilty mind. So that means when a crime is committed in certain areas of law, which you'll go to know, they have to have that. These two elements have to be present. Mens rea means guilty mind, as I said, and actus reus means the physical act. Now, a lot of the time people can get mixed up by saying it's the guilty act and guilty mind. It's not. It's the guilty mind and the physical act. So it's really just them committing the crime. Yeah, so as I said, with this, the prosecution has to prove a link between the act and the crime, and it has to be at least the substantial cause of the crime, and this is known as the causation. So I'll say that again. I'll say that not only does it have to prove the physical act of committing the crime, but within this, the prosecution must also show that there is a link between the act and the crime. and so where it has to be the substantial cause. And the perfect example is below here is RV Munter 2009, in which the accused punched an elderly man who consequently suffered a heart attack and died. So the causation is there. He punched him, he had a heart attack and died. So he can be charged with murder or manslaughter. You can have a look up the case to see what the result of that was. Move on to the final part of this area. Is, are there any offences that don't require one of these elements? Yes. There's things such called strict liability offences, and this is where the prosecution doesn't have to prove that they intended to commit the crime. So all they have to have is the actus reus, or the proof that it happened, and the causation. So the link between the act and the person who committed the act and the crime. This is a perfect example is speeding. Whenever you help into a car, you have very strict liability. So it means you really, any drink driving, any speeding, you don't have to prove that you intended to speed or you intended to drink and drive. You just have to do it and you'll be charged. Yeah, so an overview there is the 5 questions. What is crime? How do we classify crime? What inherent tension is present? What are the elements of a crime? And are there any offences that don't require one of these elements? You can have a look back through the slides in the video, and I hope that helped. Thank you for watching.